This chart plots the historical volume of green cards issued. In 2024 alone, the U.S. granted lawful permanent resident status to 1.36 million people. Breaking this down, 55.8% went to family-sponsored applicants, 14.5% to employment, 7.3% to refugees, and 4.9% through the diversity lottery. But those high top-line numbers mask a core illusion in the immigration system. Meeting the strict legal requirements for a green card does not guarantee you will get one in a timely manner. The system operates on strict quotas. Your nationality and your specific type of sponsor dictate everything. Depending on those two variables, your wait time could be 6 months, or it could be 2 decades. Securing a green card is an exercise in demographic routing, choosing an application lane based only on theoretical eligibility, rather than the practical viability of the wait time, can cost you years of your life. Historically, the Diversity Immigrant Visa Program served as a vital alternative. It provided up to 55,000 visas annually for individuals who did not have U.S. family members or employer ties. In December 2025, Homeland Security Director Kristi Noem announced an executive order that abruptly suspended the green card lottery. The Trump administration ordered the suspension to advance specific immigration and multicultural policy goals. Officials explicitly linked the policy decision to security concerns, determining that a suspect in the 2025 university shootings had entered the country through the lottery system. With that low-friction lane closed, prospective immigrants have to ruthlessly evaluate the family and employment pathways that remain, and the massive structural backlogs attached to them. The highest volume pathway is family sponsorship. If you are a spouse, an unmarried child under 21, or the parent of an adult U.S. citizen, the system categorizes you as an immediate relative. The outcome for this specific tier is highly favorable. The law grants immediate relatives uncapped visa availability. There is no annual limit. The trade-off here is purely administrative. Despite having no visa limits, standard government processing backlogs still impose a 6 to 12-month delay. However, if you are a married adult child or a sibling of a U.S. citizen, the rules change completely. These applicants are relegated to the F3 or F4 preference categories. Unlike immediate relatives, these categories are bound by strict fixed annual quotas. This visualization maps wait times for F4 sibling visas. Because the law prevents any single nation from claiming over 7% of total visas, applicants born in high-demand countries like Mexico, India, and the Philippines face wait times of 17 to 24 years. While family sponsorship dominates total green card volume, the data clarifies the reality. Extended family pathways function strictly as generational backup plans, not actionable strategies. The next major pathway is employment. This requires securing a U.S. employer who is willing to sponsor you for an EB-2 or EB-3 professional visa. The mandatory first hurdle is the Perm Labor Certification. Before filing for your visa, the employer must legally prove to the government that they cannot find a minimally qualified U.S. worker to fill the position. This trendline chart reveals the core trade-off of the employment lane: record-breaking processing times. In fiscal year 2025, the average standard wait reached 1,256 days, roughly 3.5 years. That timeline introduces severe career risk. You remain legally tied to a specific employer and a specific role for years. If you face a layoff, your entire immigration status is immediately in danger. To manage this, professionals apply for an adjustment of status while already legally working in the U.S. on a temporary dual-intent visa, like an H-1B. Adjusting your status allows you to live and work locally while the paperwork clears, but it comes with its own restriction. Your international mobility is frozen unless the government grants you an explicit travel document known as advance parole. The talent pathway demands a multi-year commitment of mutual dependency. Professionals must weigh their need for career flexibility against the ultimate goal of permanent residency. There are specific routes designed to bypass standard backlogs, provided you meet the criteria for an Extraordinary Ability EB-1 visa or a National Interest Waiver. If you qualify, you bypass the Perm Labor Certification entirely, and you do not need a corporate sponsor. The trade-off is the intensely high evidentiary standard. These lanes require extensive proof of international recognition, effectively restricting them to elite researchers, athletes, and executives. For those without that specific resume, there is a capital-driven route. Under the EB-5 category, you can invest $900,000 into a rural U.S. project that creates a minimum of 10 American jobs. A fast track exists in the family lane for applicants married to a U.S. citizen for under 2 years, the CR, or conditional resident category. Both the EB-5 investor and the recent spouse share the exact same catch. Your permanent residency is granted strictly on a 2-year conditional basis. After 24 months, you must prove that the jobs were actually created, or that the marriage remains legitimate. Fail to do so, and your conditional status expires, automatically triggering deportation proceedings. These fast-tracked lanes trade time for either immense capital, exceptional talent, or intense post-approval government scrutiny. The U.S. immigration architecture relies on a rigid structure. It overwhelmingly favors immediate family ties above all else, followed by highly specialized or capitalized talent. If you are an immediate relative, expect a 6 to 12-month administrative process. If you are already inside the U.S., file your petitions concurrently to overlap processing times and mitigate delays. If you are relying on global talent and an employer sponsor, brace for a 3.5-year commitment. You must calculate the opportunity cost of remaining locked into a single job role during that window. For those without immediate family or willing corporate sponsors, the reality is stark. With the diversity lottery suspended and historical registry dates frozen at 1972, low-friction pathways no longer exist. A green card grants unmatched legal rights and a clear path to citizenship. But success requires meticulous upfront strategy, ensuring that the lane you commit to actually aligns with your realistic life timeline.